30 minutes.
My lady, can I turn to deal, I hope briefly, with the third of the respondent's grounds, which is that it's said that certain claimants have not pleaded any actionable loss, and this relates to 34 claimants who it is said have not claimed or pleaded distress. First of all, as a matter of detail, some of the 34, a small number, do in fact say they suffered distress. Examples are claimant 368 and claimant 397, 368 and 397. More importantly, all of these 34 assert an emotional reaction equivalent to distress, and in particular assert anxiety or stress. This is summarized in an annex, which is annex to our skeleton argument. It's in the core bundle at page 121.
121. Do we have to thank your junior for the work contained in this annex? If so, thank you.
You certainly don't have to thank me, but I don't know whether it was...
Funny enough, I didn't think I did.
or my instructing solicitor. It was originally an exhibit to a witness statement. You can see from the top of it.
Yes. Just so often juniors and instructing solicitors have the pleasure of producing documents like this. I think it's nice to acknowledge it.
Yes. Well, the aim of it is to, at least in part, to avoid having to try your patience with going through yet further schedules. But you see what's summarised here in relation to each of the 34 as to the anxiety or stress that they assert. And my lady will get a flavour simply from reading the first page. In addition, I should make clear that before the judge there were statements from at least some of these 34 explaining their symptoms and that the symptoms were not modest and explaining the significance of them. And you will see that none of these claimants, none of these 34, rely simply on annoyance or upset. They all plead anxiety. We looked this morning, my lady, at section 168 of the 2018 Act, which states that non-material damage includes distress. It does not preclude reliance on equivalent states such as anxiety or stress. Anxiety, we've seen from the medical reports, can be a medical condition, and it would be irrational, I submit, if a person could claim and cover compensation for distress but not for anxiety, equivalent to distress. And finally, I would make clear that the judge did not consider claims should be struck out on this basis. If I can take you to paragraph 61(3) of the judgment, which is in the core bundle at page 59. You'll see the subparagraph relates to claimant 109A Gemma Holly. And you'll you'll see that Miss Holly had stated that she had been caused annoyance and anxiety, but would not describe the emotion as distress. The feeling of anxiety has lessened over time. So she was within a cohort that the respondent was seeking to strike out on the basis that they hadn't pleaded distress or didn't have leave an actionable loss, but that was rejected by the judge, and she's one of the, or was one of the 14 surviving claimants. So the judge plainly thought there was no merit in that point, and that a emotion equivalent to distress would be sufficient. So in summary, we submit these 34 all have perfectly viable claims that they have suffered non-material damage. Those are my submissions.
Well, I would wonder whether your junior would like to make any additional submissions.
I'm grateful, but no, thank you very much.
Any further questions? Not from me. No. Thank you very much indeed. That's most helpful. Now, over to the Commissioner, please.
My name is, my Lord, I'm conscious on behalf of the Commissioner that the central issue which arises on the appellant's appeal is one on which there's no real contested argument. And I don't want to test the court's patience excessively, but the Commissioner does agree with the observations previously expressed by the court that that issue is one of some importance and principle, and perhaps particularly given what we say is the fundamental misunderstanding of the judge of a core concept of the legislation, and in that context it perhaps warrants going through the law in a little detail, notwithstanding that there's little dispute about it. On the plus side, I'm not going to any unagreed bundle.
Good.
The learned judge's ruling at paragraph 146 of the judgment below, which you've seen a number of times now.
Yes.
Real
possibility.
Yes, was that the sending out of an ABS by post to an incorrect address did not amount to processing, or in his words, real processing, for the purposes of the data protection legislation, unless it was opened by an unauthorised third party. And the Commissioner says that that is wrong in law. Can I make my submissions by reference to the following 5 propositions? First, the legislative concept of processing is at the heart of how the GDPR operates, including where the data subject may be unaware of that processing, still less publication to a third party. Second, the concept is deliberately a very broad one, both purposive and linguistic reasons. Third, processing is not generally to be considered without reference to the contextual set or chain of operations on data.
Say that again.
Yes,
I've missed a little bit.
Processing is not generally to be considered without reference to the contextual set or chain of operations on data, as this court held in Campbell. Perhaps easier to summarise it as the Campbell point.
The Campbell point, yeah.
Fourth, the concept is not unlimited and must be read in particular with the material scope of the legislation. And fifth, drawing those threads together, the judge was wrong, paragraph 146, to find there had been no processing at all. You also have a note from the Commissioner on the threshold of seriousness issue. I don't propose to make any oral submissions about that, but if there's time and you have any questions for me, obviously I'm happy to assist on that or indeed any other issue which arises. So to turn then to the first submission, that the concept of processing is at the heart of how the GDPR operates. That should be a trite proposition, but it's nonetheless useful to emphasise it because the judge's approach to seeking disclosure to third parties is so inconsistent with how we say that data protection law works. You have the text of the General Data Protection Regulation. Now, the EU GDPR in this will tab 4 of your bundle beginning at page 17. And it's sufficient to make the point about the critical and central nature of the concept of processing, to how all the rights and obligations imposed by the legislation work, by reference to Article 5 on page 26. Article 5, as the court will be aware, is really the powerhouse provision of the whole legislation. It sets out the central data protection principles, and all of them, as is prefigured in the heading, the section heading to Article 5, are expressly about how data is to be processed. The word appears in every one of Articles 5(1)(a) to F. And importantly, when the court looks at those individual principles, many of them will be operating in some or most cases, whether or not the personal data in question has been disclosed to a third party, or indeed is known about by the data subject at all. Those points come out perhaps most obviously from subparagraphs D, E and F, bottom of page 26 and over on to 27. So D is the accuracy principle, that personal data must be accurate and where necessary kept up to date, taking reasonable steps to do so, having regard to the purposes for which they are processed. And that is primarily an internal obligation on the controller by reference to the data that they hold and use. And that applies whether or not they're actively using it, or whether they've disclosed it or never disclosed it or will ever disclose it. Similarly, in E, the storage limitation principle, data must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the data is processed. So again, by definition, E is about retention, regardless of whether it's been disclosed. And there are cases, for example, where data subjects discover, to their surprise and concern, that data continues to be retained by a controller, and they seek to exercise their rights to bring that situation to an end. And F, a principle of particular relevance to these proceedings, the integrity and confidentiality principle, data must be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorised or unlawful processing, and against accidental loss, destruction, or damage. So again, some of those concepts not dependent on disclosure to others for there to be a breach. Destruction is a good example. In fact, a classic high-profile example is something like Windrush, where there is the problem caused to the data subjects is the accidental deletion, destruction of data, the very opposite of publication, but there can in principle still be an infringement of the requirements of the legislation. And Articles 24 and 32, I don't ask you to turn them up, you have them in the bundle, on which the appellant relies, they're more specific iterations of that duty in F about data security obligations. And again, those provisions are all framed by the processing which is carried on by the controller. And we say the same is shot through the entirety of the GDPR, with which you have not been troubled.
So do I understand you don't endorse the distinction we find in the appellant's argument between processing in breach of the principles and infringement, which is treated as a separate?
No, we don't.
That was, as you will have seen from our judgment on the permission application, that was an issue that sort of arose
Yes.
incidentally and has emerged since, I think.
Yes, and I wasn't quite sure the extent to which it fell within my permitted wheelhouse of processing as opposed to the other issues.
Well, speaking for myself, I'm not sure we need to decide it.
No, very, very unlikely you do. But by way of brief headline, we say, easiest to turn it up, well, as you've asked the question, my lord. So, Article 82 is at page 37. I think it's Article 82 from which this point arises. So we say, and all of the case law of which I'm aware is by reference to the right to claim damages is given in Article 82.1. What Article 82.2 does is not to create some different additional right, but rather to explain how, first, it operates distinctly as against a controller, how Article 82.1 operates distinctly as against a controller or processor. So there are different rules, first sentence and second sentence of Article 82.2. And in the context of a controller, if you're any controller involved in the processing, you are simply liable for the damage caused. And what that formulation does is, in particular, is to make clear and to lead into the provision that is then dealt with in 82.4, the situation where you have more than one controller who may be potentially liable for the damage in question. And the purpose of 82.2 and indeed 82.4 is to say this is not the data subject's problem. It's effectively joint for several liability, and then controllers can fight it out between themselves as to who reimburses each other later down the line. The data subject shouldn't be disadvantaged. And so ultimately, although I understand the sort of linguistic point the appellant takes between the absence of the word processing in 82.1, that is ultimately a distinction without a difference, because all infringements involve processing of some kind. So to go back to the example we were talking about a moment ago on appropriate data security measures, contrary to 51F, 24 and 32, for example, failing to encrypt a database that is then unlawfully accessed. Why is that an infringement? It's an infringement because the controller is continuing to process the data in an unencrypted database. Yeah. And so there's no real, Article 82.1 doesn't need to say processing. It's inherent in how...
Given the breadth of the concept of processing, there's just no room for an infringement without any processing.
Yes.
Because mere holding without adequate security measures will be a processing of the data which is in breach of Principle F.
That's how it cashes out.
Yeah.
Yes. And to give a different example that we refer to in a different context in our threshold of seriousness note. So there are obligations which are very sort of, one might think of as effectively administrative on the controller. So for example, the obligation in Article 30 to keep a record of processing activities. Very unlikely that a data subject will ever really be able to show damage from breach of that obligation. And there is an infringement, but again, it's all in the context of processing. It's either directly about...
Well, you might have someone who is fearful that something might have happened that they don't know about because there's no record of what happened.
Yeah, well, I didn't say... The rule is out absolutely. It's one of the more unlikely ones.
Yeah.
But again, although the obligation is about an administrative step that's, I suppose, a step removed from the processing directly, it is obviously about, inherently linked to the processing. That's what the record is to be of. And so, ultimately, that's the difference being drawn by the appellant. We say it's not a correct one. Also, ultimately, I'm not sure it really goes anywhere. I don't need it. And to be fair to my learned friend, I think he expressly is advancing it as an alternative.
Yeah, he's put it as a fallback.
If for some reason the judge is right about processing. So to move then to the second submission, that the concept of processing is a broad one, can I go back to Article 1 of the GDPR on page 23. Invariably in these cases, a lot of emphasis is based on the rights protective principles in the recitals, but actually you don't need them. You get them from Article 1. Article 1 emphasises, particularly 1.2, that the legislation is there to protect fundamental rights and freedoms of natural persons, and in particular their right to the protection of personal data. It's a protective regime. That is its purpose, and that drives the meaning of everything that follows. It's the short point. Article 2, which I don't think you looked at this morning, material scope. So that explains what this regulation applies to. And although it applies to almost everything, it's not quite everything. And so it only applies to the processing of personal data wholly or partly by automated means. And then as the exception to that, the processing other than by automated means of personal data which form part of a filing system or intended to form part of a filing system. And then over the page, the definition of processing, Article 4.2, which is in materially the same terms as in the predecessor directive and the 98 Act. Processing, I emphasise the wording any operation, whether or not by automated means, such as, and then although then my learned friend this morning skipped over the various examples given in the language, but they're important to address the judge's point. So take, for example, organisation, structuring and storage. Those are all expressly forms of processing. Inconceivable they've got anything to do with disclosure to third parties. And then otherwise making available. All of that language is telegraphing as clearly as possible that is intended to be as broad as possible. And if that weren't, and if a general purposive approach weren't sufficient, I think, I'm sure my learned friend showed you this morning, I apologise if I missed it. Recital 15, on page 19, is linked, we say, both to Article 2.1 and to processing. In order to prevent creating a serious risk of circumvention, protection of natural persons should be technologically neutral and not depend on the techniques used. The protection of natural persons should apply to the processing of personal data by automated means as well as to manual processing if filing system. So that purposive point, you interpret these provisions in order to avoid risk of circumvention, including by reference to developing technologies. I've emphasised to you a breadth of the language which is apparent from the words themselves and the non-exhaustive language, particularly that of such as. And if the words weren't sufficient for themselves, that understanding is shared by both the Court of Justice and this Court. And you've probably seen the passages in my skeleton, but a helpful passage from the Court of Justice making this point is in the SSSIA case, and perhaps I don't need to ask you to turn it up, I'll just give you the references. Tab 36 of the authorities bundle, page 888. Case was about a request by the Latvian tax authorities for details of vehicle sale advertisements for the SSSIA website. And one of the questions referred by the Latvian courts was about whether or not this context was something regulated by the GDPR. Paragraph 35, Court of Justice considers whether or not it's processing. Cite Article 4.2, it is apparent, and this passage is in written submissions, it's apparent from the wording of that provision, in particular from the expression any operation, that the EU legislature intended to give the concept of processing a broad scope. That interpretation is corroborated by the non-exhaustive nature expressed by the phrase such as of the operations mentioned in that provision. And then over the subsequent paragraphs, they go on to explain what is involved in that case. It involves various sorts of processing. And then domestically, very similar point in very similar language, from this court in Campbell, in which I'm going to spend a little bit of time, if I may, under both this and the next head. But just under this head, and again, this passage you'll have seen in the written submissions, paragraph 101,
Sorry, tab.
behind tab 6, sorry, behind tab 7, on page 111 of the authorities bundle. First sentence of paragraph 101, the definition of processing and the directive in act alike, as I say, material in the same terms under the GDPR, is very wide. And just to complete the purposive point of the second submission, see also paragraph 96, the judgment of the Court of Appeal in Campbell, back a page on 110, interpreting the Act appropriate to look to the directive for assistance, interpret in a manner consistent with the directive, not appropriate to look for the sort of precision in language to be expected from a parliamentary draftsman, a purposive approach to making sense of the provisions is called for, and then immediately cites the references and the recitals to a privacy protective purpose in particular. And that, both under the directive and now, that is the consistent purposive lodestar of the data protection regime. With the third submission, that processing is, try and put it positively, I think the multiple negatives were possibly confusing. Processing is generally to be considered by reference to the contextual set or chain of operations on the data. And that is because the very breadth of the definition of processing means that what a controller does with personal data can invariably be broken into multiple different stages. And sometimes that matters and sometimes it doesn't. For that point, against a passage that is set out in our skeleton of paragraph 15, but see paragraph 72 of the Court of Justice's judgment in Fashion ID, which you have, don't ask you to turn it up, tab 35, page 882. Page 882 of the authorities bundle, that's paragraph 72 of Fashion ID, making that point about the set of obligations, a number of operations involving different stages in the processing. But then can I spend a little longer on this point in Campbell? So Campbell, as the court will be well aware, was about the publication of articles and photographs of Naomi Campbell, particularly leaving a Narcotics Anonymous meeting in the Daily Mirror. And at first instance, and in this court, there was a DPA claim which disappeared by the time it went to House of Lords. At the Court of Appeal, the judgment delivered by the Lord Chief Justice, starts this reference to the data protection claim in paragraph 72 on page 104, introduces the Act in slightly disobliging terms about its inelegance and complexity. But to be fair, there was by this point very little litigation about the Data Protection Act and everyone was getting used to it. Paragraph 73, the court there recognises the foremost aim of the regime as being the protection of individuals against prejudice as a consequence of processing of their personal data, including invasion of privacy. And then importantly, contextually, paragraph 74, that paragraph explained that below, before the judge, the press had conceded that their publication of Miss Campbell's personal data in the articles in the hard copy newspapers printed and sold had constituted processing, and on appeal they withdrew that concession, and so this court had to confront that issue of principle. Lots of consequential issues around the journalism exemption as a result, which we needn't spend any time on, particularly given the time. But then the discussion of that issue begins at paragraph 96, as you can see on page 110, through to paragraph 106. I don't ask you to go over 96. Seeing the opening of paragraph 101 on page 111, and then after that first sentence about the breadth, the court recalls the language used in the definition of processing, and notes that given their natural meaning, the language of the legislation would embrace the publication of hard copies of documents on which the data has been printed, and goes on to check whether that is the sensible outcome. And I emphasise in particular paragraph 103. The directive in the Act defined processing as any operational set of operations. At one end of the process, obtaining the information is included, and at the other end, using the information. While neither activity in itself may sensibly amount to processing, if that activity is carried on by or at the instigation of a data controller as defined and is linked to automated processing of the data, we can see no reason why the entire set of operations should not fall within the scope of the legislation. On the contrary, we consider there are good reasons why it should. I do emphasise the language of linked to automated processing and entire set of operations being brought within the scope. And then at paragraphs 104 to 105, the court go on to explain those consequential reasoning as to why that is the right outcome. In particular, noting that the hard copy publication stage at issue on the facts there was the very stage that was most likely to generate distress, and that if that was to be excluded from the scope, that would undermine the effectiveness of the remedy provisions in both the directive and the Act, and indeed the privacy protective aim of the legislation. And then at paragraph 106, accordingly we conclude that where the controller is responsible for the publication of hard copies that reproduce data that has previously been processed by means of equipment operating automatically, the publication forms part of the processing and falls within the scope of the Act.
It's a funny thing to recall that at that time this newspaper was not being published online.
Yes.
It would have been an odd case to run. We would have had to concede that the online publication was clearly processing, but the hard copy wasn't. That kind of highlights the oddity.
Yes, and there's obviously aspects of how the issue comes about which are very much anchored in the particular time and place. Yeah. But the Commissioner submits that, as a matter of logic, there is a helpful and quite close analogy to the facts here. All of the recording and extraction of address data of the claimants and the printing of that data onto the statements are part of automated stages of processing. And whether or not those letters are then placed into envelopes and then into the postal system, whether that happens by hand or by machine, I don't think we know on the evidence, matters not. They're the hard copy dissemination of personal data previously processed by means of equipment operating automatically, and so to conclude otherwise, the judge did here, would, as in Campbell, undermine the effectiveness of the ability of data subjects to articulate and seek to prove, if they can, a claim for damage caused by some of those steps of processing, which can be shown to be an infringement of the GDPR. The court will recall that that third submission was carefully framed using the word generally, and I'm not seeking to erect absolute or completist rules, because the fourth submission is that the concept is not unlimited, and in particular it must be read with the material scope of the legislation. So, unsurprisingly, the Commissioner does accept that however broad the concept of processing is, there are limits to it. And in particular, although processing itself on its language may be whether or not by automated means, the GDPR's scope is set differently. That's the Article 2 point. You recall the terms of Article 2.1. The GDPR only applies where the processing is wholly or partly by automated means, or if it's manual, it's part of a filing system. And I've given you in the paragraph 17 of my skeleton the tests for the filing system NIM. We don't need to get into that for the purposes of this argument. The limits to the concept, in the context of the limits to the concept, it's also necessary, I think properly, to address the judgment of this court in Johnson and the Medical Defence League, which is, so far as I'm aware, the only reported domestic case to find that a claim act of apparent processing did not in fact meet the statutory definition then under the 98 Act and the directive. And it is a case of some difficulty. The judgment is at tab 10 of the authorities bundle, starting at page and one can take the context of the case conveniently from the report. The claimant was a surgeon who was a member of the MDU, which provided him professional indemnity cover. And his record caused the MDU to carry out a risk assessment review, which involved a risk manager analysing and selecting information from a number of different files concerning the claimants, some of which were manual, some of which were electronic, and then entering them on, and her views of them onto a risk assessment review form, which was created on a computer. And then that form was on the MDU systems, and a subsequently committee of clinicians appointed by the MDU considered the form and terminated the claimant's membership of the MDU. And at trial, there was an issue as to whether the selection of information to fill out that risk assessment review form constituted processing or not. And the defendant, the core line of between the parties was the defendant said, the MDU said, well, the risk manager is not engaged in any automatic processing, it's her manual selection. And the claimant says, well, it's part of a whole series of automatic processing steps. This particular one is manual, and that's sufficient, and the judge agreed with that as part of continuous chain of operations. And the Court of Appeal, by a majority of 2 to 1, allowed the MDU's cross-appeal on the processing issue. Paragraph 2 of the leading judgment of Lord Justice Buxton sets the scene, and I think it may be fair to say sets the scene in a way which makes it abundantly clear what the answer is going to be when one gets to the end of that judgment, particularly given the references in paragraphs 2 to the fact that Mr. Johnson recognised he had no claim as a matter of contract or otherwise in domestic law, couldn't complain of the decision, however unfair it was, accepted they had an absolute discretion to terminate his membership. But the fact that the decision to terminate involved dealing with and assessing information about him that was held on a computer is said to change the entire case, because he can now claim not that the decision itself was unfair or not open to the MDU, but that the processing of the information that led to that decision was done unfairly, contrary to first data protection principle. At the end of the paragraph, absent the computer, none of these claims would have been maintainable under the 1998 Act nor under any other chapter of English law. As I say, that telegraphs where the outcome is going to end up for Lord Justice Buxton. But it is important to emphasise the particular way in which the case was pleaded and advanced. As we say, that is significant when one comes to address which of Campbell and Johnson's a more helpful guide. So paragraph 21, page 172, is of some significance. And he sets out, Lord Justice Buxton sets out there that the processing of Mr. Johnson's personal data took place at various stages, including in relation to computer files. But in order to succeed, by letter F, Mr. Johnson has not merely to identify an act of processing his data, but to identify such an act that was done unfairly. And that act was said by him in his particulars to be selecting the information contained in the personal data and thereby presenting a false picture of the situation. The selection was the process performed by Dr. Roberts when she drew up the form. And then paragraph 23, first sentence over the page, the difficulty Mr. Johnson remains that the selection, and thus the carrying out of operations of which he complains, was done by Dr. Roberts using her own judgment, not by any computer or by any automatic means. And similar point made at the end of paragraph 24, the selection of data of which complaint is made was all done not by a machine but by a human being. She made the decisions complained of and no automatic process entered into that decision making. So very closely confined by reference to the pleading to that very specific stage. And at paragraph 30 to 32, Lord Justice Buxton rejects the rationale of the judge below that the processing could be seen as one continuous and single operation. And in particular, he says at paragraph 31, the claim presented in the proceedings is not that the operation taken as a whole was unfair, it's that the very specific selection stage was unfair, so you can't get away from that. I paraphrase how he puts it, but you can't get away from that by reference to the continuous set of operations which isn't in fact in issue. And then at paragraphs 38 to 41, Lord Justice Buxton addresses the consistency or otherwise of that of his preferred outcome with the decision in Campbell. And note in particular paragraph 38 his agreement with the judge that the reasoning in Campbell is an extremely broad approach and it, in its literal terms, encompasses as processing the selection of data undertaken by Dr. Roberts, i.e. if I apply Campbell based on what it appears to say, the judge and Mr. Johnson are right, but he goes on then to explain why he feels he's not compelled to accept that. He's able to distinguish it. And there's partly in paragraph 40 a point about a very different sort of level of privacy involved, i.e. in his view none in Mr. Johnson's case. But the critical point is paragraph 39, in which Lord Justice Buxton says that it's perfectly possible to say, with deference to the court in Campbell, that the publication of information that has already been automatically processed can, in accordance with the aims of the legislation, be regarded as falling within its terms, without taking the same view, the manual analysis of data before any automated processing begins. And that, in my submission, seems to be the core distinction drawn between Johnson and Campbell. I don't want to take up too much time going more extensively through the other judgments. Lord Justice Longmore's very short concurring judgment helpfully summarises the gist of the arguments in two paragraphs, 155 to 156 for your note, page 210. And in the minority, Lady Justice Harden, as she then was, dissents, let's say, fairly vigorously on that point. And I'll just give you the references to the most important paragraphs. This is the dissent only. Paragraph 82 is her summary of her reasons. She makes the point at paragraph 99 that the collection and recording of data about people is very much an Article 8 concern. See the sort of database cases that were then being decided, of which there have been manifold further ones since. And the core of her reasoning is really in paragraphs 109 to 110 and 127 to 129. And she, unsurprisingly, reaches the view that her analysis is much more consistent with that of the judgment in Campbell. I take you through Johnson partly because of its slightly different nature and addressing the pointed principles approach to make sure you've seen the most difficult of the processing cases. The first point, and perhaps the obvious one, is that there is no sense that any of this nuance formed any part of either the argument, and still less the reasoning of the judge below in his judgment. His approach was a very different one at that publication point. And no one is attempting to advance the argument that had he thought about it in the sort of Johnson-esque way, could have reached the same view on a different basis. Secondly, on the facts here, the analogy we say is much closer to Campbell than to Johnson. The posting is the end result of an automated process. To pick up Lord Justice Buxton's key reasoning in paragraph 39, posting here is the end result of an automated process, not a carefully distinguished manual decision-making stage prior to automated processing. And thirdly, and the court may not need the third reason, but to you for completeness, the Commissioner does respectfully suggest that the majority judgment in Johnson is wrong in its attempt to distinguish Campbell. It has adopted an excessively formalistic and narrow approach to processing, which is, particularly in the light of the nearly 2 decades of Court of Justice and domestic case law on processing, usually taken as read, that is not consistent with the purposive anti-avoidance approach emphasised in both the case law and more expressly in particularly the recitals of the GDPR than was the case in the 95 Directive. And ultimately, the better answer was that given by Lady Justice Arden, that it was processing, but it was clearly fair processing in context. Ultimately, I fully recognise the court is unlikely to need to go that far, and it would be sufficient to say, and we do invite the court to say, that Johnson can be confined to its particular facts and the particular way that the case was pleaded and advanced in that context, and ultimately doesn't assist in resolving the present appeal, and is unlikely to assist in resolving issues of processing more generally. And that leaves the fifth submission that the judge was wrong to find no processing. I mean, this can be taken very quickly because you have points on what I've been saying along. The judge erred. I don't repeat the more detailed analysis set out in paragraphs 19 to 27, my skeleton, the application to the facts as we understand them. But we do say it is artificial and wrong to suggest that, as I think was this ground traversed a bit at the permission stage, to say that no operation was performed on the data in the transmission of the statements. On the contrary, we say operations of selection and printing and posting have been performed on the data in the statement, and they are all closely connected, or in the language of Campbell, linked to the inaccurate address data being processed on the respondent's systems. And you have what we say is a helpful analogy from the facts of Campbell. And so the real question, the touchstone of processing, contrary to the judge's approach, is not disclosure or publication. Those may simply be two elements in a much longer set of operations, all of which may constitute processing acts. And the real question is whether that processing involved an infringement, and whether that infringement caused recoverable damage. And that is the appropriate stage to resolve the issues arising on the facts, rather than to read processing in an artificially narrow way. Those are the submissions I wanted to make on processing. If there's anything I can assist you with on that ground or any of the other data protection issues, obviously the Commission is happy to assist.
Just on the second threshold of seriousness point, I'm not inviting you to go into the submissions that you've advanced in writing, but there's the topic that we debated briefly about which GDPR we're talking about here.
Yes.
I think the answer, now I understand, is that we are talking about the EU regulation at the Material Times, and that it only became the UK GDPR on IP completion date, which was the 31st of December 2020.
That's exactly right. Yes.
In the interim, there were legislative opportunities which were taken in the secondary legislation that resulted in the UK GDPR to make amendments if Parliament so wished.
Yes, and one amendment that I should mention briefly, because I haven't mentioned it as we were going through, but one of the things that the UK GDPR does is that it rewrites or restructures the terms of Article 2, for example, not least because the material scope of EU law is not really a problem that UK GDPR needs to confront in most cases. The content of Article 2.1 in the EU GDPR about wholly or partly automated meaning, that's all still there in Article 2, it's just in a different place. So Article 2 is a provision that's quite significantly restructured in the UK GDPR, as an example. Yes, on the facts, this was a breach which occurred at the latest August 2019, as I understand it. That is within the purview of the original GDPR, before the division between UK and EU GDPR became effective. I don't, as I understand it, none of the issues on this case actually would alter, regardless of which regime applies. The only one of the CJEU cases you have a bundle that is pre-IP completion date and therefore forms part of assimilated law and binds you is the Fashion ID case. All of the subsequent ones fall within the looser
regard.
Yeah.
the looser due regard test, and I think that's common ground between us all. On the harmonisation point, certainly for the Commissioner, we don't place any particular weight on the harmonisation rationale, which is clearly in the CJEU's judgments, as you would expect it to be. Usually is in CJEU judgment somewhere. But the core of the points that they make in the UI case and in all of the other cases is driven principally and primarily by the language of Article 82, which is the same point we make, and the appellants has already made in more detail. So yes, the harmonisation rationale perhaps doesn't add very much when you're in a regime which either has been or is about to be domesticated.
Well, yes, I mean, that is one of the issues. Obviously, there's no need to harmonise with the regime of a different group of countries that we're not part of now. But it might be said that that's a political choice and a legislative choice,
Well, certainly from
and we don't have any guidance one way or the other on it.
No, well, certainly from the Commissioner's point of view, the Commissioner invariably seeks to adopt an interpretation of the GDPR which is consistent with the CJEU's approach, unless clearly directed to do otherwise, either by the intervention of Parliament or by the domestic courts. Precisely, I mean, essentially for legal certainty reasons.
And we're still trading with other countries.
Well, it's important for adequacy decision making on a higher policy level that we don't depart from the EU GDPR approach without good reason and thought having been given to it. But also, obviously, everyone who is seeking to apply the GDPR will have an eye to what the CJEU says its terms mean, and one would wish to be quite careful in taking a different approach to those judgments. Obviously not impossible to do so, but the Commissioner tends to avoid doing so unless there's a clear domestic direction to do so, in accordance with the ordinary constitutional principles.
Thank you very much.
No, thank you very much indeed.
Thank you very much.
Yes, Mr. Charland.
Good afternoon, my ladies and my lord. I'm going to begin with a roadmap of my oral submissions this afternoon and tomorrow. Firstly, I will briefly, I emphasise the word briefly, address the generic facts applicable to every case. Secondly, I will make submissions on the applicable law, and I intend to address the court on five areas. The first area I will address the court on is the appeal issue, which the appellants summarise in paragraph 2 of their skeleton argument. That's at court bundle page 96. And they summarise it in the following terms. Whether the judge was wrong to hold that each appellant only had a viable case under the data protection legislation if it could be shown that their personal data had been published to a third party as a result of a personal data breach. That's how they characterise it in the skeleton. Now, we say the judge was right to hold that a viable claim under the data protection legislation in this case can only be advanced where there has been publication or disclosure to a third party, albeit, and this is an important caveat, he should have reached that conclusion because of the absence of non-material harm, or in the alternative, lack of sufficiently serious harm in such near-miss cases, rather than the absence of processing. So we say his ultimate conclusion was right, but the route that he took to get there wasn't. And my lord, you've obviously heard what my learned friends have said on the processing issue. As we flagged up in our skeleton, I'm not running any arguments to the contrary, so I won't be addressing you on that. But we do say, and I think this accords with what my learned friend Mr. Knight for the ICO concluded his submissions was, this wasn't a processing issue. You should be looking at the issue of damage, non-material harm, non-material damage in this case. The basis of that argument is an authority you've been taken to by my learned friend Mr. Campbell this morning, the BL against Media Market Saturn case, which I will be returning to in my submissions. So that's the first issue I'm going to address. If the court is with me on this argument, there is no need to address the individual particulars. of damage. The second argument, the second legal issue I'm going to address is the threshold of seriousness, which we say applies to data breach damages claims under the GDPR and the Data Protection Act 2018 in the same way that they applied under the previous legal regime set out in the Data Protection Act 1998. Third area I'm going to address is Jamil abuse of process and the importance of proportionality. Fourthly, what actionable harm is necessary to found a claim for breach of the GDPR, Data Protection Act 2018? Must the claimant allege that he or she has suffered distress, or is it sufficient to merely assert upset, annoyance, or anxiety? And finally, and very briefly, the issue which we deal with in one of the annexes to our skeleton argument, the issue of repetition in the particular claim, and a little bit of law on that. So those are the 5 legal areas I'm going to address. I won't be addressing processing. Once I've addressed those areas, I will explain why all the individual claims should be struck out. I will do that by reference to 1, the generic facts which apply in relation to every single case and make every single claim for damage completely unreal. Again, if you're with me on that argument, no need to look at any of the individual particulars. But if the court requires further persuasion, by reference to the 9 schedules of damage selected by the appellants, including the supplementary bundle, various individual cases they cited as the most serious below, and some of the schedules that they referred to today. My lady, I very much got the point that you don't want me spending hours on this, and I won't be. So please don't worry about that. I will ensure I'm well within my time limit, and I will not detain the court for hours going through schedule after schedule. I will. It's important that it's dealt with efficiently, and I will ensure it is done so, my lady.
Thank you.
However, my ladies and my lord, before I turn briefly to generic facts, there are 1, possibly 2 preliminary matters I want to address at the outset. Firstly, the issue of the unagreed bundles of documents, specifically in the individual particulars. And secondly, and this is to the extent the court thinks is necessary, I'll address the appellant's argument that appears in their skeleton argument but wasn't developed orally, that we're not entitled to run the points we're running on the respondent's notice. If that is a live point, it's obviously something we need to address, but I plan to do it quickly.
Well, if it's a good point, it needs to be addressed, whether or not it's being run by the appellants. It's a formal point. If
Yes.
it's got some merit, it needs to be looked at.
Yes, my lord. Well, as I said, I was planning to address you on it. There's recent case law which Lady Justice Whipple was a member of the court. I'm not going to take a long time on it. I don't think it's a difficult point. So, first preliminary point, the need for the bundles of individual particulars. My lord, I'm grateful to that the court granted our application to file the 4 unagreed bundles containing the individual particulars in advance of today's hearing. I do, of course, understand the concerns raised in your order about the practicability of determining the viability of all the claims when the court below did not make its decision to strike out on the basis of our arguments on this issue. I know those concerns are shared by other members of the court. My lords, my lady, in summary, what we didn't want to be faced with an argument is, well, the court can't address the respondent's notice point and strike out the claim because you don't have the particulars. There's more serious particulars that you don't have, and therefore, essentially, our argument would be defeated before I open my mouth, and that's what we're trying to meet. But I'm not going to take you through every one. My learned friend took you through a few. I will respond to some of those. But we are asking the court to strike out all the individual claims. And I hope to persuade the court that that is an appropriate approach. And my lord, this is a point that is important to my client. given the history of this claim, and in particular the very substantial delay that has already occurred in this matter, caused, we say, in part by the appellant's unreasonable conduct of the litigation, and in part by the court below taking 1 week short of a year to deliver a judgment, it should do so. Just going to take, if I could beg your patience for 5 minutes, take the court briefly through the factual matters that we say support our assertion that this delay has been caused by the appellant's unreasonable conduct. Just quick chronology, my lady. I'm not going to delay the court long. So August 2019, the ABSs in question were misposted. February 2020, we have the letter before action. March 2021, the claimants made a without notice anonymity application requesting inter alia the identity of all claimants be withheld. Mr. Justice Nicklin subsequently concluded that this broad application was wholly inappropriate and the claimants had failed to adduce relevant evidence to support it. 22nd of April 2021, the claim was issued on behalf of 474 claimants. In breach of the requirements of CPR PD 53B, the appellants failed to provide the required full details of the facts and matters on which they rely in their claim for damages. No application was made to disapply this provision at the time or subsequently. The appellant's solicitors initially refused to tell the respondent which individual police officers were bringing the claim. That's paragraph 17 of the judgment where Mr. Justice Nicklin refers to that. The appellant's solicitors wrongly asserted that we were not entitled to this information as a result of the anonymity order. It took nearly a month before the appellant provided the respondent with a schedule identifying who the claimants were in this matter. 14th of May 2021 we had that information.
14th
of May 2021. And the claim was issued on the 22nd of April 2021. The respondent sought to agree an extension of time to file its defence, in part because the appellants had refused for nearly a month to tell us who was bringing the claim. A short extension was agreed, but the appellants refused a further extension, which necessitated an application to the court. Master Dagnall subsequently extended time for the filing of defence as we sought. Respondent requested particulars of the claim for damages, without which it was not able properly to analyse the merits of the claims and consider whether to apply to strike some or all of the claimants out. Similarly, it was not able to decide whether it was appropriate to settle some of the claims. The appellants repeatedly refused to provide that information, notwithstanding that they were required to do so under the CPR. So in March 2022, we made a Part 18 request for further information, namely the full details of facts relied on for damage. The appellant again refused to provide that information, and we were forced to make an application to the court. On the 27th of April 2022, Master Dagnall ordered the appellants to provide full details of the facts and matters on which they rely in support of their claim for damages. You've been taken to the order, it's a supplementary bundle 411 to 415, don't need to go there. The appellant was required to provide such particulars by the end of June 2022, which they did so. So the individual particulars, and these are the individual particulars you have in 4 unagreed bundles. So it took 15 months after issue before we had the particulars of damage that should have been included when the particulars of claim was issued. There's been considerable delay up to that point, and as you will see, considerable expense was incurred because it was necessary to trouble the master on various applications. In October 2022, less than 3 months after the individual particulars were provided, we made our application to strike out and summary judgment. The matter was listed before Mr. Justice Nicklin on the 27th and 28th of February. 2023. On the 23rd of February 2024, 4 days short of a year later, the judgment was handed down. It did not address the respondent's grounds for striking out or summary judgment, save that it made some important observations as to the apparent lack of seriousness of certain claims, which I'm going to come to later on. It's now June 2025, over 4 years after the claim was issued, and the strikeout summary judgment application has still not been finally determined. So it is a great cause of concern for my client. I just wanted to convey this to the court. We are asking the court to deal with all the claims. And indeed, we think the CPR requires the particulars, the individual schedules to be before the court. The core bundle requires particulars of claim to be included in the core bundle. That's tab 12. And we think these are part of the particulars of claim. That's what CPR PV 53B, paragraph 2.2 suggests. So I understand the court's displeasure, annoyance about them being put in, but that's the reason. And we say, actually, we think the parties were required by the CPR to include them in the core bundle. We wanted them in the core bundle, but there was a dispute about whether they actually were particulars of claim, but it was agreed they should go in the supplementary bundle. That agreement ceased when Master Meacher raised concerns about this, so they were no longer agreed. But there was a point where it was agreed between the parties that they should be before the court. So with that history, we say that if at all possible, we would ask the court to consider all the applications, because if they don't and the matter is remitted back, there is going to be further delay, further cost, which we wish to avoid if at all possible. Second preliminary issue, my ladies and my lord. At paragraph 99 to 101 of their skeleton, which is CB 113 to 114, the appellants contend that the respondent is not entitled to raise the argument by way of the respondent's notice and must cross-appeal if it wishes to advance these arguments. This is simply wrong. Mr. Justice Nicklin's order is at page 93 of the core bundle. At page 94, paragraph 1, save for the 14 claimants where there was evidence that ABS had been opened, the order provides the claims, the remaining claimants are struck out pursuant to CPR 3.42a. We are seeking to uphold the court's precise order, albeit on different grounds, i.e. the 3 grounds on which we applied to strike out or obtain summary judgment when we issued our application notice.
Are you? I'm about to say it seemed to me that there was, it may not matter, but it seems to me that there are 2 points on which you may be seeking something different. First of all, you're seeking, as I understand it, summary judgment on the merits, which is not CPR 3.42a, it's part 24, on the basis that some of the particulars are incredible and they have no realistic prospect of success. Secondly, and whether or not I'm right about that, you're seeking to strike out as an abuse, which is CPR 3.42.
Sorry, I didn't catch.
You're seeking to strike out as an abuse, which is CPR 3.42b, not A. It's a different ground. So the judge threw it out on the basis that the pleaded case was not capable of sustaining liability. So you can say that, but I think technically you're seeking a different order by some of your 3 grounds.
Well, my lord, we're seeking to strike out all the claims. My lord, you make the point about summary judgment. It may be the order didn't fully capture the court's decision on this. At paragraph 147 of the court's judgment, which is page 88 of the core bundle,
He said he would have struck it out. He would have given summary judgment if he hadn't struck it out, but he didn't because he'd struck it out. This happens all the time. So yes, I mean, he would have given summary judgment for the reasons he gave. I mean, I don't think this is, as it were, a state trial issue.
no.
But since it's been raised, it seemed to me that we might as well think it through. It may be that we would give you permission out of time
Well, my lord,
if you needed it.
to the extent it's necessary, I would ask permission, but of course, everyone has prepared on this basis. You granted the ICO permission to make submissions on the threshold of seriousness, which implicitly recognises that that is properly before the court, I would suggest. Yes, we say we can do it on the respondent's notice, but if the court disagrees, there's clearly no prejudice to anyone, and it would be inconsistent with the overriding objective to shut us out at this point, I would suggest. The relevant case, my lord and my ladies, is brace yourself at tab 30 of the bundle, which sets out the correct approach. And as I mentioned, Lady Justice Whipple was involved in that case. Paragraphs 17 and 18 set out the relevant provisions of GDPR. A respondent who seeks to appeal against any part of the order made by the court below must file an appeal notice. A respondent who seeks a variation of the order must file an appeal notice and must obtain permission. My lord, maybe you're suggesting that we're seeking a technical variation of the precise basis of the strikeout, and if that is necessary, we would seek permission for that, my lord. But there's clearly no prejudice. Everyone's clear what everyone is arguing about, and everyone has proceeded on that basis. So we don't accept that we do need an appellant's notice, but to the extent we do, we would ask the court's permission. We say there's no prejudice. My ladies and my lord, can I now turn to the generic facts? I set these out in skeleton argument, paragraph 6 onwards. My learned friend, Mr. Campbell, took you to some of the documents, and I do want to take this relatively quickly. The court is no doubt familiar with pensions and pensions annual benefit statements. They no doubt receive them by virtue of their membership of the judicial pension scheme. They are essentially, they provide a snapshot of a pension scheme member's accrued benefits under the scheme, an estimate of the value of the scheme, and the member's expected pension payments upon retirement. It's an annual forecast rather than a guarantee. And as public servants, a significant amount of information concerned the remuneration and pension arrangements of police officers such as the claimant is already publicly available. There are seven slightly different templates of the ABS, but nothing really turns on that. Paragraph 6.3, I address the relevant information that's contained in them. And that is referred to in the claimant's generic particulars of the claim. And I think it would be useful to turn that up because I think it goes to a point raised by Lady Justice Whipple. So could I ask the court to turn to page 231 of the core bundle? So this is the master particulars of claim, and at top of page 231 you have paragraph 3.4 where the claimant sets out the information relating to each claimant. And at paragraph 3.5 that is said to be the personal data, and at paragraph 4.1 there's a reference back to that is also the private information. That's for the misuse claim that has now gone. And you have A to N, but what you don't have in that list is identification of the claimant's employment as a police officer. So Lady Justice Whipple asked about the ABS and said, well, does it say that they are currently a police officer? The important point is the fact that they are currently employed as a police officer is not part of the asserted personal information relied upon in this claim. There is reference, I accept, for example, to police service details, but that is something different, and you'll see that is explained in the supplementary bundle, the witness statement of Mr. Green. It's page 11 of the supplementary bundle. At the bottom, of page 11, Mr. Green explains that police service record relates to service history information such as interruption in period of continuous employment and so forth. So there isn't a complaint about status as a police officer. Similarly, there is no reference to any contact information. It's common ground that the ABSs in issue did not contain contact information other than the out-of-date address, but the out-of-date address is not part of the personal data complained about. And we say that the information in this document is anodyne. It doesn't include, for example, any medical information. It doesn't include any financial information, such as bank account details or passwords. There's no telephone number or email address to contact the appellant. There is nothing to indicate that the particular appellant has a particular police rank or is deployed in a particularly sensitive area of policing. So we do maintain the description of anodyne, trivial information, low-level personal data. It is not sensitive personal data. There is very little, if any, scope of misuse, even if the information was obtained by nefarious third parties.
Should they not work out from the content, if they saw it, that the person was a police officer because they're the people who are members of the police pension scheme?
They could work that out, and it. Assuming that ABSs only go to current members, and it's possible they may also go to former members. But again, that is not the pleaded case. That is not. It is not said in the master particular. Now, it is said in some of the individual particulars. It's said, I keep the fact that I'm a police officer very quiet. I don't tell anyone about it. And I was very upset when that was disclosed. But that is not the pleaded case as set out in the master particulars. And that's the point I'm going to come back to, my lord. So we maintain the view that this is very low-level personal data. And that view was shared, and we'll come to this, by both the force and the ICO. So it's not just our view. Now, the ABSs were sent out in opaque white envelopes with a window. In the case of each appellant, their name but nothing that indicated that they were a police officer, and the words private and confidential were visible through the envelope window. A return address, the respondent's address, office in Crawley, was marked on the rear of the envelope. And in each case, the ABS was only sent to one address, which had previously been provided by the appellant as the correct address where they live and where the ABS should be sent. The misposting came to light quickly. Paragraph 8 of my skeleton argument deals with this. And then every member whose ABS had been sent to an out-of-date address was written to by the force and was informed of this. There's two versions of the letter. It's in the supplementary bundle 142 to 143. That is the version that went to members of the pension scheme, where at the time, the 4th of October, their ABS had not been returned. And you'll see this is a letter from the police. This isn't a letter from Equiniti. Page 142, 143. The police say the risk of harm arising from this breach is assessed as low. However, officers should take the following steps to protect themselves from any residual risk. And there's various suggestions, and there's reference there to the UK Fraud Prevention Service, CFAS, which provides extra protection. And over the page 275, 276, there's the version of the letter, and the only difference there is this was sent to those where the unopened ABS had already been returned to Equiniti by that date. So in relation to some police officers, the first they're aware of this is when they receive this letter, and they're told, well, it's already been returned unopened. Replacement statements were then sent to the claimant's respective correct address in early October 2019 with an apology from the respondent. Further general update from Sussex Police was sent to all affected members on the 4th of November 2019. That's a supplementary bundle 147. I don't think you were taken to this letter, albeit you were taken to the FAQ that was attached to this letter. And over at 148, there is again reference to the option of taking up CFAS protection, and it said this will be funded by Equiniti. There's an email address given if you want to take that up. But only 5% of the police officers were sufficiently concerned that they did take that up. The next paragraph, just below the top hole punch, says a number of you contact us with further questions, including some answers to this in the attached FAQ document, which you'll see at 139. And again, there is reference to CFAS protection, what the police officers needed to do if they had any even minor concerns here. Page 141 of the FAQs details what needs to be done if the individual police officers wish to make a complaint. The relevant address for Equiniti is set out there, and how quickly Equiniti will respond. So it's essentially saying, if you have any concerns about this, here's how you make a complaint. But only one formal complaint was made. if you look at the contemporaneous evidence, at what happened at the time, we suggest that indicates the level of concern from the police officers was virtually zero. And the bundle includes all the relevant sort of correspondence that could, however broadly the phrase is defined, amount to a complaint. But properly analysed, it really is only one complaint raised. If I could ask the court to turn to page 149 of the bundle. This is a record of a telephone call from Claimant 365, where it's member calls to say not received an ABS from last year or this year, address held for member is incorrect. So Equiniti hadn't been provided with the correct address in relation to that. But there's no suggestion that the individual is particularly distressed. It's just asking for a copy, he or she is asking for a copy of the ABS. Similarly, 151, member called, address is incorrect, hasn't been received, changed address, but raised for staff. I'm not quite sure what that refers to. Page 152, payment 410, called asking for ABS to be resent to him. Similarly, 153, requesting ABS be sent to him. The 153 letter is dated the 7th of October, so that likely is in response to the letter from the 4th informing police officers or certain police officers that their ABS has been sent to an out-of-date address. Page 156, you have Claimant 89, member called regarding the letters, presumably the letters are received on the 4th. Someone has called back and apologised, so a swift apology. At 161, we have Claimant 248. Good morning, I emailed you in November 2019 but had no reply from you. I'm a serving police officer, paid into pension until 2013. Due to the change of pension I left. Not been receiving any annual pension letters from you, which I'm guessing it should have been sent. The reason Claimant 248 did not receive any ABS is they were not an active member of the police pension at the time. From 2013 through to 2020, they weren't an active member, so they weren't sent ABSs. So there was no misposting in relation to this. Notwithstanding that, Claimant 248 issued a claim setting out significant distress caused by the alleged misposting. That has subsequently been withdrawn. I'll take you to that very briefly tomorrow. So the only formal complaint that the respondent received is from Claimant number 1. And you'll see that at page 157 of the supplementary bundle. This is Michael Farley, who said...
Sorry, could you give the page number again?
Yes, page 157 of the supplementary bundle, my lord. And he refers to being worried. The stranger now has all of my details, including where I work and all of my personal data. So no suggestion he's distressed, merely worried. And that worry is that a stranger knows where he works. But there's nothing in the ABS indicates a work address, nothing in the ABS that indicates a home address. Then says that this stranger has, quotes, all of my personal data. But of course, that's not remotely accurate. If, and in relation to this individual, the court concluded that his ABS hadn't been opened, but on the assumption that it had been opened, the stranger would not have all of Mr. Farley's personal data, would have no contact details, no medical details, no bank details. So what you have here is essentially the genesis of this group action, Claimant 1, who did raise a formal complaint. But if you actually analyse what he said, it doesn't provide contemporaneous evidence of any distress, we say. And even if you're against me on this, all of the other 430, there is no contemporaneous evidence of distress. Now, as is good practice, the Information Commissioner's Office were notified of the incident by the force, who regarded themselves as the data controller. And in October 2019, the Information Commissioner concluded that no further action was necessary. And you'll see what the Information Commissioner said at page 166 and 167. Here the ICO says, decided no further action is necessary. First, to the fact that the force has conducted a risk assessment and concluded the risk of data subjects suffering significant consequences as a result of this incident is unlikely. Data disclosed is limited in nature, and each data set had only been sent to one household who could be identified. And then goes on to say we've had contact with the data processor and so forth. So that is the police's analysis of why this is a low-level data breach, a trivial data breach. That explanation has been sent to the ICO, and the ICO hasn't taken issue with it. The ICO, of course, is not bound by the data controller's analysis. The ICO is perfectly entitled to take a different view. But in this case, the ICO did not do so. The ICO agreed with Sussex Police and agreed with Equiniti that the risk here is low for the reasons given. Data disclosed is limited in nature, only been sent to one household who can be identified. Paragraph 9, my ladies and my lords, I set out various categories of what happened to the ABSs. My learned friend took you to that. I don't think I need to go through that now. I know you have read it. And paragraph 10 is where we set out details of the appellants who we say should be struck out on grounds 3. Is where they haven't pleaded distress. And again, I'll address you on what is necessary for actionable harm tomorrow. My lady, that's all I want to say on the facts, unless there's anything else the court wanted. So I'm now going to turn to the first issue of law, which is the appeal issue, whether the judge was wrong to hold that each appellant only had a viable claim under the data protection legislation if it could be shown that their personal data had been published to a third party as a result of a personal data breach. You've already been taken to what Mr. Justice Nicklin said on that. he concluded, drawing an analogy from the tort of misuse of private information, that where there is no disclosure or publication of personal data in question, a near miss case in his words, there is no claim because there is no real processing of the personal data for the purposes of GDPR. What appears to have underpinned this analysis was the fact that the data protection regime is concerned to a great extent with protecting privacy rights, not solely, but to a great extent. The whole data protection regime came out of case law of the European Court of Human Rights on Article 8, the right to private life. That is its genesis, albeit I quite accept it has evolved beyond that. Mr. Justice Nicklin's view was where there is no disclosure of personal data in issue to third parties, there's no impact on the data subject's privacy rights, and therefore no claim. Now, Mr. Justice Nicklin's analysis did not reflect our arguments on the strikeout, but it is our case that the learned judge was right to hold that a viable claim for damages for distress under the legislation could not be advanced where there's no publication of a third party, since the distress in this case is said to have been caused by the fear of misuse of the data by third parties. My learned friend referred you to the Osterpost case and said, well, there was no disclosure in that case. That's very true, but the basis of the claim damage was not fear of misuse in that. It was inappropriate processing and associating an individual with a particular political party on the basis of where he lived. Here, the basis of the distress, see the master particulars of claim, is fear of misuse of the data by third parties.
Can I just rewind you to paragraph 137 of the judgment, which I asked Mr. Campbell about?
Yes.
You'll recall that attributed to you in that paragraph is a contention. This is page 86 of the core bundle, paragraph 137. The judge attributes to you, as you point out, a year after you made these submissions, a contention that publication is an essential element of each cause of action. Do you recognise that as a description of what you said?
No, I would agree that the learned judge has misunderstood the arguments we were advancing. We definitely didn't advance a no processing argument. We did make the point that publication was relevant to the issue of whether there was damage and whether the threshold of seriousness had been overcome. So it's not a complete misunderstanding. We didn't say absence of publication was irrelevant, but it wasn't, we didn't make the point.
No processing without publication.
Yes. And I think paragraph 37 of the judgment, which is page 50 and 51 of the core bundle, the court sets out our defence, and at subparagraph 5, which is just by the top hole punch on page 51, says defendant denied that mere handling of an unopened opaque envelope could constitute misuse. So that's the tort claim that's gone. Brackets, or conceivably give rise to any actionable damage, whether for misuse of private information or under data protection law. So that is the argument we were advancing in defence. That was the argument we advanced orally before the court, where you have an unopened envelope and no one sees the data, you don't have actionable damage. We never ran a processing argument. You've seen the pleadings. We expressly admitted processing in this case. So yes, we do think the learned judge misremembered or misunderstood our submissions, but not completely, because we were running a point in relation to publication, but we say, we said then and we say now that it goes to material harm. He should have reached conclusion because there is an absence of non-material harm in such near-miss cases rather than an absence of processing. So the judge's instincts on this issue were right. even though his precise legal analysis was not. There is no viable claim for damages for distress in the present case by reason of all the generic facts that I've referred to, including but not limited to the lack of publication. And even if there is some distress caused by the misposting, it would not have been serious enough to cross the applicable threshold. So those are the 3 points. One, if you don't have disclosure, there is an absence of non-material harm. Anyway, there's no viable claim for damages in the present case as a result of all the generic facts, including but not limited to publication. And if you're against me on those 2 points, even if there is some distress caused by misposting, it would not have been serious enough to cross the applicable threshold. Now, our argument on the first point is supported by the recent judgment of the European Court of Justice in the media-marked Saturn case, which you were taken to by my learned friend. This was sent to the court on Friday in soft copy and handed up today. I have inserted it at the end of the second volume of Authorities. I think it's 43. I don't know where the court has placed it. I've called it Authority number 43, but the court may have it elsewhere. Before we look at that case, can I briefly take you to the appellant's skeleton argument, which discusses the issue of fear of misuse, but doesn't refer to this case. Fear of misuse is considered at paragraph 83 to 95 of the appellant skeleton argument. That's pages 111 and 112 of the core bundle. And in those paragraphs, the appellants advance an argument on the basis of fear of misuse, relying on the VB case. And you'll see at paragraph 89 of the skeleton argument, they set out the question that the court was addressing in the VB case. And it is absolutely critical that one bears in mind the facts of the VB case, because they are fundamentally different to the facts in the present case. In the VB case, it was common ground that large amounts of sensitive personal data have been placed on the internet and therefore published to the world. And the question, given that factual matrix, is set out at paragraph 89 of my learned friend's skeleton, is Article 82.1 and 2 of the GDPR read in conjunction with recitals 85 and 146 thereof to be interpreted as meaning that in a case such as the present one, involving a personal data breach consisting in unauthorised access to and dissemination of personal data by means of a hacking attack, the worries, fears and anxieties suffered by the data subject with regard to possible misuse of personal data in the future fall per se within the concept of non-material damage, which is to be interpreted broadly, entitle him or her to compensation for damage where such misuse has not been established and or the data subject has not suffered any further harm. So the question the court was addressing is where personal data, sensitive personal data, has been published to the world and the individual claimant has no idea who may have seen it, what they may have done with it, whether on that basis there is scope for bringing a claim, and that falls within the concept of non-material damage. And the court in VB said, unsurprisingly, yes, that does fall within the scope of non-material damage. And my learned friend extrapolates in this skeleton, well, that must apply to the present case where there is no evidence of dissemination of the personal data to any third parties, let alone to the world. And that extrapolation is misconceived. It is wrong. The VB case is not authority for that proposition. It doesn't deal with that issue. Its analysis is predicated on the existence of widespread publication. However, the Media Market Saturn case does deal with this very issue. The factual background is set out paragraph 16 to 20. Now, my friend did take you to it, but took you to it quite quickly. Could I ask the court to read carefully 16 to 20?
Certainly. 16 to 20.
Yes. So, a couple of points I want to take from this. The personal data in question in this case was significantly more sensitive than in issue in this appeal. It included contact details such as home address, also included bank details. The personal data was given by mistake to a third party. Unlike the present case, there's no suggestion that that personal data was in a sealed envelope. Now, my learned friend, when he took you to this case, said, well, there's evidence of discomfort, but no pleaded distress. But nowhere that I can see in this report does it say mere discomfort, not distress. The summary doesn't detail the level of non-material harm alleged by the individual. It could well be he claimed to have suffered great distress, but it's not really addressed. Now, paragraph 25, which I don't think you were taken to, but I think, my lord, you picked it up. The referring court asks whether, even if it seems that the unauthorised third party was not aware of the personal data concerned before returning the document containing that data, the existence of non-material damage within the meaning of Article 82 may be established from the mere fact that the person whose data was thus transmitted is fearful of the risk, which cannot be excluded according to that court. So the word seems suggests that the individual in question had not been able to proffer any evidence that the third party had viewed the personal data, but there was no evidence either way. So we say it is very similar to the present case. If anything, the present case is weaker because we have a clear finding from the court below, which is unappealed. We say the personal data was not considered. But
I'm just looking at actually now,
yes, my lord.
rather than that version of the issue, the quotation of the questions referred in paragraph 28 goes a little further. Question 5 is whether non-material damage within the meaning of Article 82, whether that's incurred, even where the third party received the document containing the personal data, did not read the data.
Yes.
So that was the word. So
Yeah,
the question was put on the footing that there was no reading.
Yes, and that is the footing this court is considering the 431. There is no reading because the envelopes weren't opened. So it is directly on point, my lord. I accept the facts are different, but the basic points are identical. The key points. And paragraph 62 through to 69 are where the court considers this question, question 5. And the critical paragraphs are paragraphs 67 and 68. Paragraph 67, it says, similarly, in the present case, it should be noted that it's consistent both with the wording of Article 82.1 of the GDPR and the objective of protection referred to by that regulation, that the concept of non-material damage encompasses a situation in which the data subject experiences the well-founded fear, which is for the National Court to determine that some of his or her personal data be subject to dissemination or misuse by third parties in the future on account of the fact that a document containing those data was provided to an unauthorised third party who was afforded that opportunity to take copies before returning it. So what the court is saying in paragraph 67 is it has to be a well-founded fear. And they go on at paragraph 68. However, the fact remains that it is for the applicant in an action for compensation under Article 82 of the GDPR to demonstrate the existence of such damage. In particular, a purely hypothetical risk of misuse by an unauthorised third party cannot give rise to compensation. This is so when no third party became aware of the personal data at issue. And applying those two principles set out by the ECJ, we say there is no well-founded fear in this case, given the fact that envelopes were addressed to the appellant, third parties generally do not open correspondence that is addressed to someone else and labelled private and confidential. An assumption fear the other way is unreasonable and irrational. It is not well-founded. As all the appellants knew, where the envelopes went, often to former family homes still occupied by family members, even if the envelopes had been opened, the information inside was anodyne, not able to be actually misused, even if there was a motive to do so. So we say there is no well-founded fear, paragraph 67 of the BL case. But further, paragraph 68, the risk in all the cases before you is purely hypothetical. And we say it is now common ground that no third party became aware of the personal data in issue. It remained in a sealed envelope read by no one. That is what we say the court concluded below, and there's no appeal in relation to that finding. It might assist if we look at what the court said about this.
Before we leave that, can I ask you a question about paragraph 67?
Yes.
The concept of well-founded fear comes up quite a lot in different contexts in this court, and it's an objective test. Do you say that's an objective test that the court is posing there? So it's to do with the reasonableness of the response to what's happened?
Yes, I do, my lady, and I think that's what the court has used that phrase, which of course it is used elsewhere. It's used in refugee convention cases, amongst other things. So yes, we do say it is an objective test. That is the approach the court is advocating here. Yes. So if we could turn to the core bundle. Judgment of Mr. Justice Nicklin at paragraphs 98 to 99, which is page 71 to 72 of the core bundle, the judge sets out our arguments on this issue, which he went on to accept.
So paragraphs?
98 to 99, page 71 and 72 of the
Yeah, thank you.
and then analogy here was being drawn with the law of defamation. We argued that there was no basis for the appellant's asserted inference that the letters had been opened. The case law suggested otherwise. Learned Judge set that out, paragraph 98 to 99. And he went on to address his mind to this at pages 88 to 89. It's paragraphs 148 to 153. And in essence, the court accepted our argument on this point and rejected the appellant's assertion that the court must assume that the letters have been opened. And he proceeded to conclude, therefore, that there had been, this was a near miss case, they hadn't been read, and therefore no processing. Now, the last step is wrong, that's common ground. But he did conclude, essentially, in the language of the European Court of Justice, that you only have a purely hypothetical risk here because no third party became aware of the personal data at issue. In consequence, there has never been any recoverable non-material damage. If you accept our argument on this, like Mr. Justice Nicklin, you will not need to consider the individual particulars of damage, as this argument is a complete answer to all the 431 claims. That's all I wanted to say on that point, and it's about a minute to 4 o'clock, so I'm very happy to pause there. I'm confident I will stay within my time estimate and we will finish.
Why was the timetable? Had someone got meetings or something?
We're finishing early at 3:15. The timetable provides for
No, I meant for today.
today and 3:15 tomorrow, starting early, 10 o'clock both days.
Did my clerk ask you to stop at 4 today, or was it?
I can't remember. I thought that was our understanding, and that was what the timetable said. If you want me to carry on, I'm happy to carry on, but I don't think I need to stay within my time limit. And I'd quite like to sort of go through my submissions, take into account the points made by my learned friend and the points raised by the court, so hopefully I can take them a bit more quickly.
Well, as you know, that's always a seductive argument.
Well, while we're here, can I just ask this point? I don't think these cases give us the answer to this question, but you may have one. There may be a range of situations between the extreme where it's obvious that the data that were misaddressed or sent to the wrong person were never looked at, and it's obvious immediately within the half an hour of the mistaken handing over of the documents and the Hoover or whatever it was. And at the other end of the scale, a situation where for many months the data subject's been left in uncertainty, and it turns out on a close examination of the facts that, contrary to their well-founded fears, nothing actually happened. Where are we? Are all the cases in one or other of those categories, or is there a possibility of
Well, my lord, a couple of points. You said at one extreme you had the BL case.
Yeah.
I don't think it is obvious in that case that the personal data wasn't looked at. It wasn't in a sealed envelope. And it's unclear from the report. It said it seems it wasn't looked at. So so BL wasn't able to establish it had been looked at. But I don't think there was any positive finding. Well, it's hard to tell because that's an issue that had been addressed, I think, by the German court, and we don't have a detailed report of that. But my lord, I've just taken you to the court's analysis of the judge's response to the inferential case pleaded by the claimant. And relying on the defamation law, he concluded that the inference was if you send a letter marked private and confidential to a named individual, that is not generally open. So I don't accept that there is any basis for a well-founded fear on the facts in this case. Because the inference that the courts draw, the defamation case law that Mr. Justice Nicklin based his conclusions on, are based in reality.
So this is different from something that gets put on the internet. One always used to say, the mere fact that someone puts a thing on the internet doesn't mean that anyone's read it, and to some extent that's still true. Whereas here, it's still there for anyone to find if they look. Whereas in this envelope situation, it's only in the place it's been sent to.
Yes.
And the only question is whether it's realistic to suppose that it was open.
Yes, and we know in relation to a significant number of the claimants, it wasn't open because it's been returned unopened. So in those cases, I would say there is no contrary argument that that is not the hypothetical situation in paragraph 98. This is so when no third party became aware of the personal data at issue. Where you have an unopened ABS being returned, that is that situation. It is hypothetical, and the court in BL is saying no claim. Now, we say the same position arises in relation to ABSs that haven't been returned, because the reasonable inference is they won't be read, and therefore any concern that they may be read is not well founded. And as I say, the court's analysis was based on defamation law, but the approach taken in the case law is based in reality.
Not often said about defamation.
Hopefully not a controversial submission. Obviously, if you receive something through the post that says £10,000 cheque enclosed, the inferences may be different. If I received a parcel saying finest Belgium chocolate, not addressed to me, unclear address, I may be tempted to open it. But if I get a letter private and confidential with a return address, I either send it back or most likely it ends up in the bin. And that's what happens, my lord. My ladies and my lord. The idea that this type of correspondence is regularly opened just is inconsistent with reality. And that's what the court found below, and there's no appeal against that. So we have to work on that basis, my lord, and applying the clear judgment of the ECJ and BL, the correct analysis in relation to all these claimants is they all fail because there's no well-founded fear, and any fear is at most hypothetical.
Thank you. 10.